Let's start with Judge Seeliger, and we'll work our way back this way.
That's quite the answer. But he says it has some effect on my attitude toward police officers who are doing their duty. Aside from that, I haven't ever been charged with any kind of criminal offense. And I don't think that makes too much difference in this case. I just do what I have to do in court, based on what I understand the facts of the law to be.
Great question. Drum roll. I have. And it came at a time where I was going through a divorce proceeding and a custody battle. Now, of course, the case was dismissed and the issues were hashed out in front of the Superior Court judge who had never given custody, or actually stated on the record that he would never give custody to a man, of a baby to a man. However, in that case, not only did this particular judge, after hearing all of the evidence, award me custody of one baby, but he awarded me custody of two, my 4-year-old twin boys. Now, what that has done to me, it made me a better prosecutor. It made me a better defense attorney. It's going to make me a darn good judge. Now, the good thing about it is over time, wounds heal. And there's no biases in my heart when I step on the beach.
Thank you very much, Judge Flake.
The only run-in that I've had with the law occurred about a month ago when I was going to a meeting in downtown Atlanta. I followed my MapQuest directions and made a right turn on Peachtree Road. It got pulled over by an Atlanta police officer. He was very respectful, and I tried to be respectful as well. But fortunately, the municipal court judge in Atlanta believed my MapQuest defense because I had my document with me and they dismissed the charge. Other than that, I've had no run-ins with the law.
Do people still use MapQuest? Anyway.
It won my case.
That might be the one area we do have an agreement in. Of course, I didn't win my case, but when I was a young person, I got a speeding ticket in New Jersey. My father went with me to court, and I sat in the back because I felt I could represent myself. I'm good at talking. And the judge sat all the way at the front and called my name, and I had to walk all the way down what seemed like ages to get to the front and explain my case to the judge. And I lost the case even though I thought I should have won. But what impressed me so and made me want to become a judge is that he listened to me, and I felt like I had some impact. And I felt like he was listening to what I had to say and thought that what I said was important. And I've always tried to do that through all my years of sitting as a judge. It doesn't matter if it's a traffic ticket or a murder charge or a death penalty. I want to be able to sit there and have every person that came into that courtroom feel like I've listened and I've made a judgment concerning what they did according to the law. And so it has impacted me, and I hope that that impact changes the community that comes before me.
Thank you. Question for Mark. Based on each of your knowledge of DeKalb County Superior Court, do you see any structural problems in the administration of fair justice? And if so, what are they, and what would the solution be? Let's start with Mr. Johnson, and we'll work around this to kind of vary it up a little bit.
Improvements can be made in every facet of life. But I think what will get us there is we got to have equality on all levels. We have to have accountability on all levels. No matter whether it's inside the courtroom, outside the courtroom. I've practiced had cases against some of you guys. I've worked with some of you guys. And I think you know that when it comes to fairness, I'm fair. You may not agree with the final outcome, but you know that I'm fair. Had one fellow in this room, sitting in this room now, beat me in a jury bench trial But at the end of the day, I guarantee you that fellow can tell you that I was fair and just in the decisions and the process that I went through. So I think we can all do better with fairness and accountability.
Let's go this way, we'll come back around. Let's go with Judge Flake.
Although we have 10 judges in Superior Court, and we all try to work together as much as possible, each judge runs their own court. My court, I believe, if you will talk to attorneys or litigants or anyone that's appeared in that court, what I consistently hear from them is that they believe I'm fair, they believe I'm unbiased, and I'm consistent. I don't favor one particular side over the other, one particular individual or defendant, that I treat everyone fairly. That's what I have always tried to do. That's what I intend to do in the future.
I think structurally, there are a couple things that can be done, and that I would strive to do, is to make the calendars more efficient. If you file for a bond hearing in my court, you'll get a bond hearing in a timely manner. That I will be fair to both sides on the criminal side, to move both sides toward efficient resolution, whether it be for trial or for plea or dismissal, and that I will hold everyone to the same standard. On the family law side, the calendars would move quicker so that you're not waiting months and years for the resolution of these cases that impact families and will decide if families stay together or if they're torn apart. So I will strive to make the court more efficient, strive to make it more attorney user-friendly, and strive to make it the appearance and perception of fairness and respectability for the indigent and the people who are representing themselves and can't afford to have lawyers.
Mr. Seeliger.
Well, I'm kind of going over ground we've already covered. Since I've been in this court, with this court in 1985, this has been a court that lives on reform. I can give you lots of different reasons. For example, Judge Flake mentioned the Family Law Center, where people can go in for a few dollars and buy a form, and take an uncontested divorce, to have their names changed, and even challenge custody or get child support. They can do it on their own. The form gives them everything they need to know that the judge can deal with it. It's far better to have a lawyer, but the Family Law Center gives that hope to people who do not have attorneys. We have a dispute resolution center. Now, dispute resolution center is where mediations take place, and it's free to litigants for at least 3 hours. So if someone wants to settle their case, they will sit down and talk to a mediator with the lawyers, or not, and they can resolve the case without having to go through the drama of trial. I believe it just shows the attitude of just about everyone on the court that sits on the court today. If change is needed, we will make the changes.
Thank you. Question from Greg.
One of the key disputes I frequently hear, I work a lot in Fulton County, I hear it a lot from the district attorney over there, and it arises here, is that judges don't give proper consideration and weight to the sentencing recommendations that prosecutors bring. Unnegotiated pleas, that's a very big sore point downtown here in DeKalb County. It sometimes goes the other way, and they give a little more perhaps than was originally agreed on. But what is your view? What is the role of the judge and the prosecutor in handling a plea?
Let's start this way.
Well, the role of the judge is to consider the facts of the case, a defendant's prior record, of course, the recommendation of the state, the recommendation of the defense attorney, but it's the judge's responsibility to determine what's the appropriate sentence in a particular case. I think if you will talk to the district attorneys and defense attorneys and public defenders that practice regularly in my court, you won't hear that complaint that Judge Flake favors one side over the other. As I said earlier, I think you will hear them all say and consistently say that I'm consistent and that I judge each case individually and treat each defendant fairly.
The judge's role, I would agree, in handling that plea is to make a determined effort that the factual basis has been made and that the sentencing is appropriate, giving all of the circumstances. When I sat on the Superior Court bench, I listened to the prosecutor's side of what they wanted, what was important, what was the weight of it. I listened to the criminal side of what was important, what mitigated, why it was important, Judge, for you not to put this particular person in prison or for this length of sentence. And I gave careful consideration to each of those and made a decision. I can promise you that if you come to court before me, I will listen to both sides. If we need to have sentencing things done, sentencing investigations done by probation so that I have a more fuller effect, a more fuller idea of what is behind this decision, then I will do so. And I will
We'll start with introductions, 1-minute introductions and 30-second introductions. We'll start with the ladies. Angela.
Good evening, I'm Angela Brown. I'm running for DeKalb County Superior Court Judge, Division 4. The judge is always the gateway to justice, and I believe that it's time for a time for a change that is essential. Experience that is essential. I have 26 years of experience, 10 years of it on the bench. I have a diversity of experience in both civil litigation and criminal litigation on both sides of both arenas. Excellence that is essential. I have been asked by this Superior Court bench to sit on the Superior Court in between the time that Judge Becker stepped down and Judge Boulay was put on the bench to administer a backlog of cases.
Thank you very much. We'll hear from Judge Flake.
Good evening. I'm Gail Flake, and I'm running for election to the DeKalb Superior Court. I have been one of your Superior Court judges since 1993, when I was initially appointed by then Governor Zell Miller, and I have been re-elected a number of times since then. Judicial candidates, of course, have to run on our reputation and our qualifications, as well as our experience. We can't take issues, we can't take positions on issues. So I would ask everyone to please consider the experience and reputation that I have earned during those 23 years.
Thank you. Mr. Johnson.
My name is Stephone Johnson, and I'm running for DeKalb County Superior Court Judge. I was a prosecutor, and I've practiced criminal law, I've practiced family law. I'm not pro-prosecution, I'm not pro-defense, I'm for what is right. Our lives matter in our community. Our kids matter. The safety of the citizens matter. And that's why I'm asking for your vote on May 24th in this coming election. Stephone Johnson.
Thank you.
Good evening. My name is Clarence Seeliger. I'm the judge of the Superior Court of DeKalb County. I was a state court judge for 4 years. I was elected in 1981, served until 1984. I was elected in 1985 to the Superior Court, and I've served the Superior Court since then. I tried to be fair, and I tried to be a good and decent judge. I thank the county for having elected me for all these many years, giving me the opportunity to serve. I would like that opportunity again. Thank you.
Thank you. First question is from Mark. Well, first in this race between Judge Seeliger and Mr. Stephone Johnson, for you, Judge Seeliger, you've been on the bench a long time, since 1985, as you mentioned. Why do you think you should continue on the bench after so many years? And Mr. Johnson, why did you choose to run against him? Judge Seeliger is well established on the bench, and you have discussed running for some judicial seat in DeKalb County, but previously you eventually landed on challenging Judge Seeliger, so why did you choose this campaign?
Well, the reason I just decided to run again is fairly simple. My wife won't let me come home. Ralph Hicks in Fulton County. He said he came to see me after he had retired and became a senior judge, and he said, Chuck, I need you to hire me to become a senior judge. I had a discussion with my wife this morning. She said, Ralph, I married you for life. I married you for love. I did not marry you for lunch. Go home or leave home. Actually, the real reason is that I've enjoyed my time on the bench. I've been honored to be elected as many times as I have. I haven't really had opposition since 1985. I've tried to serve the people of the county the best way I know how. I have some issues that have always been important to me. One is civil rights, and the other is domestic violence. I think it should be the will of the court to protect victims against violence and to sanction those who would do it against women.
Thank you, Mr. Johnson.
Thank you. Why am I challenging Judge Seeliger? You know it's God talking to you when it looks foolish and unattainable by the natural eye. Judge Seeliger and I did look at other judges to run against. Quite frankly, I believe that after 30 plus years, it's time for change. And change can be a good thing. I think we need someone who's going to give the public what they need and what they want. I don't care if it's 100 jury trials, 200 jury trials that you have to sit through. I'm going to be the attentive judge, and I'm going to sit through. I'm going to give the public exactly what they're asking for from the judge they're elected, and exactly what they need from a judge that's sitting on the bench. We're not going to pay favorites. We're not going to give the defense favors. We're not going to be favors to the prosecutor. We're going to call it right down the middle. That's what I'm here for, and that's the reason why I'm challenging Judge Seeliger.
Thank you very much. A question from Jennifer.
Are we doing each of them separate, or should they also be answering questions?
How do you?
Yes, all of them should be answering questions. And so I will redirect that question to you, Judge Flake, and to Andrew Brown. You've been on the bench for 25 years. Why do you want to continue to be on the bench? And Angela, what is it that you would do differently from what Judge Flake has been doing if you were elected?
I have been on the Superior Court bench for 23 years. I've handled hundreds of felony criminal trials. I've handled thousands of domestic cases, which include divorce, child custody, child support. I think experience is essential in a Superior Court judge, and if you have the option of selecting someone who has that experience and that judgment and has a good reputation for being fair, for being unbiased, and for knowing the law, then you should consider putting that individual back on the Superior Court. These are life-changing decisions that must be made, and we need the most qualified persons making those decisions for our citizens.
I'm running for Superior Court judge because I believe it is my legacy of service. I'm the daughter of a Tuskegee Airman and a mother who's a public school teacher. They always taught me that it is your service in whatever community that you have. I'm asking for your vote because I have the experience. It's not about why not her, it's about why me. I have the experience that this own Superior Court bench realized that was quantified and qualified enough for me to sit on the bench. And I'm asking you to, again, look at my record. I have the experience of sitting as a prosecutor, sitting as a criminal defense attorney. I have the experience of sitting on civil litigation cases as an associate in a large law firm. I have the experience of sitting as a corporate attorney responsible for half of a corporation from the Mississippi all the way out to the Pacific Ocean. I have the experience on all different sides, and I've talked to the community leaders, I've talked to lawyers, I've talked to regular Joes like you and me who have children and have a stake in this community, and they say it's time for a change. So let experience and essentiality speak for itself.
Thank you. A question from Greg.
Well, since we're doing the in-bank questions, I'm going to have to obviously level some towards the incumbents and some towards the challengers. For the incumbents, you've both been on the bench many years, had a distinguished career. This is a lot of changes going on in the justice system now. In the legislature, there's criminal justice reform. The Department of Justice has just come out with strictures that we should try to take people's means into mind. What do you have you instituted, are you considering any sort of programs, initiatives, changes in your courts that to adapt to the changing times? And obviously the other side would be, should you emerge victorious, you challengers, what have you got up your sleeves?
In the 35 years that I've been a judge of the Superior Court, we've gone through enormous changes. Reform has been a major part of our constituency. Gail and I and all the other judges working hard in several areas. One of the things that we do deal with in the law, of course, are drug cases. We've had a drug case in court in DeKalb County Superior Court for at least 10 years. It was started by Judge Castellani, and we have all supported him. And we have all supported him. As previously mentioned, we are going to have a mental health court been instituted by Judge Jackson, and that should be operational, we hope, within the next month. And finally, Judge J.P. Gouli and myself and Mark Scott, we are all veterans that are making an effort to create a veterans court to help those veterans who are now suffering from PTSD, veterans of the Vietnam War, but now Iraq and in Afghanistan. We don't want to meet their needs. We don't want to put them in jail, and that's why we need to have these kinds of reforms to divert them to receive treatment and not incarceration.
Thank you, Mr. Johnson.
I'll tell you what I would like to see different if I'm elected. I would like to see accountability. When the judge makes a decision, whether that decision is right or wrong in your eyes, but regardless of the decision that's made, the judge should be held accountable when things doesn't turn out the way that they're supposed to be. When we're given bonds, low bonds, and we're not taking the defendant's record into consideration, and that person gets out for a little bit over $10,000 and commits another murder, blood is on that judge's hands. That's a decision that that judge should be held accountable. The judge should be held accountable for decimating the state's cases where child molesters are given probation. Those are decisions that judges should be held accountable for.
Thank
Those
you.
are some of the things that I would do.
Thank you, Judge Flake.
Thank you.
I believe that the DeKalb Superior Court has been at the forefront of change over the years. We've established a number of programs to not only assist civil parties, pro se parties that are trying to represent themselves, as well as criminal defendants. We've established a family law center to help individuals who don't have attorneys to help them. We've established a mediation program so that parties can work out their issues without having to have a judge make those decisions for them. We have a drug court. We're working on our mental health court as well as a veterans court. We're trying to improve these programs, strengthen these programs. All the judges have worked well together, and I think we have a Superior Court panel and a Superior Court program that is rivaled by none in this state of Georgia, and I'm proud of it.
Some of the initiatives that I have put into place, because the alternative sentencing is very important. And so in my time as a traffic court judge, I have instituted the idea of community service to allow a person to do community service and effect some change in the community when they don't have the money to pay, and as an alternative to going to jail. I have dealt with individuals who have health problems and working out a pseudo type of mental health initiatives similar to what was in magistrate court when I was in traffic court. In Superior Court, the initiatives that I sat in was to the initiatives that I started was to hit the backlog cases, to have attorneys come to court, to have timely administration of things, to get orders out that have been sitting for days. As a new person getting on the bench, I can assure the public, I can assure the attorneys that there will be an efficient facilitation of the court process, and that things won't just be thrown through. We'll have consideration of alternative dispute.
Thank you very much. I have a question for each one of you. And we'll start with you, Ms. Brown. What is you all's stance on public access to your courtrooms? I know that doing this for a long time, there are some judges who cringe when a camera comes into court. They prefer not to see them, and I always wonder, what is there to hide? What is or what would be your stance on having your courtrooms open to the public?
See, my judicial philosophy is this is not my courtroom, okay? So it's not public access to my courtroom. It's public access to your courtroom. I am your servant. Judges are servants of the people. The judicial canons say that we have to be immersed in our community and live in the community in which we share, because that is the important mantle that we have. So if you want to come into court and watch something, absolutely, I'm going to allow it. If the media wants to come in, absolutely. The more people see what's going on in court and understand the court process, the more that there is a relationship between the court and the community. And that starts at the head with the judge's philosophy, and it trickles down to how my staff will treat you, how my court personnel will treat you, and how anything that is associated with that court will treat you with kindness and with respect and with the dignity that you deserve at every single time.
Thank you.
Again, I have a track record. You can look at what my practice has been over the years. We always allow public access to the courts and to the press. Press knows when they come in the courtroom where to put the cameras, where to put the microphones. The Supreme Court has even told us last year that infants have the constitutional right to be in courtrooms, so we've opened the courtroom to babies until they start to cry and disrupt the courtroom. But I agree, courtrooms should be open to the public unless it's some type of criminal proceeding that the law requires that the courtroom be closed to protect the defendant's rights. Then my courtroom is always open.
Mr. Johnson.
Thank you, Mr. Jones. The law requires that we let the public into the courtroom. It's not the judge's court. Sometimes people, they get sidetracked, but it's the people's court. You're the taxpayers, and you deserve to see what goes on in the courtroom. Having the public available for any hearings. I know my opponent had some mix-up with not letting the public in on certain hearings, but having any hearing available to the public, it keeps not only the judge accountable to his constituents, the people that place him or her in office, but it just gives the public a greater sense of there's integrity in the court. And there should never be a need or a time that the public is banned or shunned from seeing what happens in the court.
Thank you.
I have never regarded the press or the public from any proceeding in my court, never, in the last 35 years. In fact, when I ran for office back in 1981, the judge who preceded me, Judge J. Oscar Mitchell, used to dispose of criminal cases in his office, and that became an issue. So I challenged that issue, and it became an issue in the campaign, which I was ultimately successful. As everyone has said here, the public owns the courtrooms. You have a right to have access to it at any time. Courts have to be accountable. Prosecutors have to be accountable. Defense counsel has to be accountable, but most of all, the judge has to be accountable.
Thank you. Let's take a question from Jennifer.
Has anyone of you ever had a run-in with the law? And how is that, and how would you use that experience sit in judgment on others.